We consent to same. Mr. Al-Ashur, please state your full name for the record.
Montader Anwar Al-Ashur. Good afternoon, Your Honor.
Your Honor, at this time, I'd waive any formal reading, stand my client mute, ask that a not guilty plea be entered. I had advised him of his rights to an exam and all of the rights therein. Further, he would be requesting the assistance of assigned counsel.
Thank you very much. Mr. Al-Ashur, today's proceeding is called an arraignment. So this is not by any means your last hearing on this case. This is your first hearing. The court is entering not guilty pleas on all three of these counts. So you are presumed innocent. The court has entered your pleas of not guilty. The next step in these proceedings is called a probable cause conference. So you'll be getting notice to your Southfield Freeway address if you make your freedom today or any subsequent day. That will direct you when and how to appear for your probable cause conference. And in the meantime,
listen up. Today's arraignment looks routine, but don't be fooled. This hearing is the first domino in a case loaded with history, heavy conditions, and a bond decision that will tell you more about how the court weighs past behavior against present promises. We've got a 27-year-old defendant who just entered a not guilty plea on 3 counts, a detective pointing to a criminal record that stretches back years, and a defense saying, loudly, that this man is working 2 jobs, supporting a little girl and trying to turn his life around. Which story matters more to the judge, past warrants and probation or a steady paycheck and a family to support? Stick around because in a few minutes the judge will set strict release terms, GPS, testing, geographic bans, and drop a bond number that could determine whether this defendant gets to go home to his daughter or waits in custody. We'll break down the legal stakes, what a PCC is, why binding over to circuit court matters, and exactly what a cash-only bond means in practice. Who do you side with at this point? The prosecution calling for protection and appearance, or the defense asking for a chance to keep a family together? Hold that thought. The drama starts now.
the Oakland County Public Defender's Office will be matching you up with very competent counsel. So a new lawyer is going to want to reach out to you, and together you can make a plan as to how you're going to work through this case. If probable cause is either found or waived within the next 21 days, this case could be bound over to the Oakland County Circuit Court for further arraignment, trial, and proceedings. With all that being said, sir, the court now must turn its attention to bond. The court is not intending to prejudge or punish you. You're presumed innocent, but the court must set a bond to ensure that you do reappear and to afford any necessary protection to the public. In that regard, the court confers here, if he wishes to speak, from Detective Barretto of the Royal Police Department, and then we'll listen to your lawyer. Okay, sir? Go ahead, Detective Barretto.
Good afternoon again, Your Honor. Based on bond, Mr. Al-Ashur has an extensive criminal history dating back as far as 2016. He's currently on probation out of the Third Circuit Court. By my count, he's got 22 warrants, albeit traffic and failure to appear on said warrants. In addition, based on Al-Ashur's actions during this incident, placing himself, the responding officers, and the public in danger, I ask that the court set the appropriate cash bond with the proper conditions for Mr. Al-Ashur.
Thank you very much. Any indication that the court should have concerns related to drugs or alcohol?
No indications, Your Honor.
Thank you very much. Mr. Mitchell, what would you like to share as to bond?
Your Honor, my client is 27 years old. He's currently working 2 jobs. He works at Walmart, also a car shop. He's working 40 plus hours a week. He has a 3-year-old daughter, another baby on the way. My client did disclose to me, Your Honor, that he is currently on probation out of the Third Circuit for an attempt CCW. He did indicate to me he may have some traffic warrants. Your Honor, taking all that into account, I would ask the court just consider a reasonable bond with reasonable conditions.
Thank you very much. Mr. Mitchell, obviously per statute, given the fact that your client appears to have open warrants as well as an active probation, the court does not believe he qualifies for a personal bond. These following conditions, Mr. Al-Ashur, will apply to your release. Your hand is raised. What is it? Is there something you need to...
Pause and zoom in here. The detective just asked for a cash bond and painted a picture of risk, probation, 22 warrants, and alleged dangerous conduct. That request isn't emotional chest beating, it's a strategic move. In arraignment, prosecutors emphasize flight risk and public safety because those are the legal touchstones judges use when setting conditions. Will this person show up, and does release put others at risk? Now listen to the defense. 2 jobs, 40+ hours a week, a 3-year-old daughter, another baby on the way, the classic anchor to the community argument. Those are powerful human facts, but they don't erase the record. Here's the legal trade-off. A judge can't ignore repeated failures to appear and active warrants. Those weigh heavily toward stricter conditions like GPS, testing, and sometimes cash-only bonds. Notice what the judge does next. She orders monitoring, pretrial screening, and a geographic ban from certain businesses. Those are calibrated conditions meant to reduce both flight risk and alleged danger. Audience question: which side convinces you more in this moment? The prosecution's caution or the defense's plea that a steady job and kids deserve the benefit of the doubt? Drop a comment later, but for now watch how the judge phrases the rationale. It's all about protecting the court's ability to deliver justice, not punishment before trial.
To tell your lawyer, Mr. Alashore?
No, Your Honor. I wanted to speak to you, but I'll shut up, and I'm sorry, Your Honor. Go ahead.
Okay. You will appear as you're directed for all your future dates. You'll abide any valid order or judgment entered in this case. You're not to leave the state of Michigan without permission of the court. Please don't commit any crimes while you're on release status. Please do notify the court in writing of any change of address, telephone, or email. You will be making reports to pretrial services, and they will be contacted prior to your release. No alcohol, no marijuana, no controlled substances without a valid prescription from a treating physician. And you will participate in a testing program if directed by pretrial services. No purchase or possession of a firearm or other deadly weapon. No bars, clubs, or liquor stores. And as well, do not enter any business premises in Royal Oak or Berkeley, except for work, court, or medical reasons.
Your Honor, if I may.
You might want to clear what you're going to say with your attorney, unless if it has something to do with the bond.
Oh,
And as long as it's not something that's going to incriminate you, that's fine. Otherwise, you might want to do it in private. Mr. Mitchell, how do you want the court to proceed?
Mr. Alashore, if you want to tell the court something as it relates to bond, I've got no problem with that. I don't want you to mention anything about what did or didn't happen that gave rise to, that led to this arrest and these charges. Okay. I don't want you to talk about the incident at all. If you got something outside of that, go ahead.
I understand that, sir. Okay, Your Honor, if I may.
Yes.
Your Honor, I've been coming to this city for the past 5 years. I have not disrespected this city once. I have not been in trouble here once, Your Honor. I've been working so hard for the past 3 years. I understand it looked like I have a lot of warrants and it looked like but I've taken care of these. I've already paid a lawyer. I've paid $2,500 this year to take care of these warrants. I've been trying to take care of my tickets and fix my life for the past 3 years, Your Honor. I don't have nobody to come right now and stand here for me. I don't have not one person. It's me taking care of a girl, her daughter, and I have another baby on the way now. Your Honor, I've not been a flight risk. I show up to every probation appointment. I show up to every court hearing I've had. These traffic tickets are old. I was younger, and I'm taking care of it now. I spent the last 3 years trying to fix this thing, get it together. I work too hard. I work very hard. I show up to work every day, and I bust my ass and sweat just to see my daughter happy, and I do what if you could give me a personal bond, I just want to be in my daughter's arms. Like, I just want to show up to work in the morning, Your Honor. I don't have nothing better to do out here. I just work. I work and love my family, and that's it. I don't have nothing better going on. I understand this is this, but I'm just asking you for a personal bond, Your Honor. I really am. That's it.
Thank you. Anything further the defense would like the court to know?
No, nothing further at this time, Your Honor.
Anything further from the people?
None, Your Honor.
All right. Mr. Alashore, the court has indicated what your conditions are. The issue becomes, and we're not convening today as a debating society, so the court's about to rule. The issue becomes a propensity to fail to appear in court, which gives this court great pause. The offense itself, while you are presumed innocent, speaks of somebody who does not want to avail themselves of justice. It is within the courthouses where we are able to enjoy all of the protections of the constitutions of the state of Michigan and the federal government. If we don't go to our court dates, we can't embrace that justice. We cannot assert our presumption of innocence. We just end up with warrants. So this court is confined to a difficult circumstance here. I believe the court indicated, as we were prohibited places, no release without a GPS tether, pretrial services to screen for alcohol and substance abuse. And at this time, given everything the court knows, the bond will be $50,000 cash or surety only. Is there anything further, Mr. Mitchell?
Would the court consider a 10% provision?
Not at this time, but that motion can be renewed before Judge Kolakowski at the very first PCC. Anything further?
Nothing from the defense. Thank you, Your Honor.
All right, that completes your arraignment, Mr. Alashore. Good luck to you.
Thank you, Your Honor.
Thank you, Detective. Don't go away, Mr. Mitchell.
Quick professional wrap. At this arraignment, the court accepted a not guilty plea and explained the next step, a probable cause conference, PCC, where the case could be bound over to circuit court if probable cause is found or waived. Practically speaking, that means this is still early. Discovery, strategy, and real negotiation are coming. However, the judge's bond ruling is consequential today. The court emphasized a propensity to fail to appear, public safety concerns, and active warrants. So she set strict release conditions, GPS tethering, pretrial services, substance screening if ordered, geographic restrictions on certain businesses, and a cash bond. The transcript shows the court set the bond at $50,000 cash or shing only. The defense asked for a 10% provision, which the judge declined for now. That request can be renewed at the first PCC. What this all means, the defendant gets the presumption of innocence, but his ability to remain free before trial will hinge on meeting tough, non-negotiable conditions tied to both his past record and the court's interest in ensuring appearance and public safety. If you're thinking about broader implications, judges routinely balance rehabilitation signals, steady work, family ties, against objective risk factors, warrants, probation, and today the scales favored caution. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.